Hi there, you're with BQ Prime, and this is the fine print. Earlier this week, the Supreme Court of India gave a significant ruling for bankers in this country. The apex court said that before lenders categorize accounts as fraudulent or fraud, they need to give the borrowers an opportunity of being heard. So essentially, the apex court has read principles of natural justice in the Reserve Bank of India's master circular on fraud tagging of accounts. The apex court said that this is important because once you classify an account as fraud, it has both penal and civil consequences, some of which include no access to institutional capital for at least 5 years, no restructuring once an account is classified as fraud, and no compromise or settlement with the fraudulent borrower unless it's agreed that the criminal complaint will be continued. To understand the implications of the Supreme Court ruling for lenders and borrowers and the process of fraud tagging the accounts, I have with me Sunil Srivastava, former Deputy MD of SBI Bank, and Nilang Desai, partner at AZB. Mr. Srivastava, Nilang, welcome to the fine print. Mr. Srivastava, let me start by getting some flavor from you on what happens in the process once the banks decide, hey, look, we need to look at this account and whether any fraudulent activity has happened in it. Can you sort of weigh in on what that process currently looks like?
So, once an account becomes an NPA, even prior to that, RBI has this provision for early warning signals. There are 45 early warning signals, and you're supposed to be red flagging an account, watching out, close monitoring of the account. Once an account becomes an NPA, normally banks follow the practice of fixing the staff accountability and taking appropriate action. If in the staff accountability, there's a staff complicity or negligence or lack of knowledge, or if there is a fraudulent activity on the part of the borrower, then these are reported, as within specified timelines as per RBI in what is called the fraud monitoring report to RBI. Initial report, and then there is a final report. Now that is the process which is usually carried on. And frauds have been reported in the past, but in 2018-19 perhaps, there was a circular, 2017-18, there was a circular which obligated banks to refer all cases of frauds for defaults over 50 crores to a forensic audit. Now, when all cases are given, and this CC 50 crores and above is a large number of accounts, and there could be failures on account of economic conditions, or perhaps in AQR there would have been NPAs, or for various other reasons, or there could be genuine cases which actually failed, and you need to assert that. But once you refer to a forensic auditor, the initial tendency was that you would either there are outright cases of fraud, which was evidenced by some accounting trail, or there would be cases of suspicious, suspect fraud cases, where perhaps in case of a working capital given to a corporate, and if he's going through a tough time, the first thing to vanish is the inventory, the raw material and the finished goods, etc. Now there also it was treated as a case of diversion, or there could be a case of diversion where he's using short-term funds for long-term purposes, or vice versa, which is also not allowed by the bank. So now that is a case of a suspect fraud, but not too many evidences. And the third case was the gray area, where everything appeared to be largely kosher, but because the account had become an NPA, obviously there was some, there's no corporate in India which follows all the rules and regulations and all the accounting principles to the T. In my 45 years in the corporate banking, I've yet to come across any corporate which says that I'm following every rule and regulation, everything to the T, and more so prior to a couple of years back, where you had 37 inspectors. So obviously there were leakages. Now those leakages were not really established, you not evidence. So a forensic auditor, while giving his report, either in the first case, which is evidence, which is a clear case of fraud, suspect of fraud, okay, you can establish whether it's for internal diversion or external diversion. External diversion becomes a fraud. and if there are grey cases. So even when he was giving his report, in grey cases, normally he would just caveat it by saying that these may require further examination, could be possible cases of fraud.
Which is then investigated by the relevant investigating and enforcement authority.
Now, when that report goes to the person who's examining it in the bank, obviously it's not the senior most guy, it's the junior most guy who examines it in the ladder, and he also summarizes the report but says that there could be a possibility of this fraud. Now the question is whether this should be reported as a fraud or not reported as a fraud. So the guy at the bottom of the ladder is there could be a possibility of the fraud, so nobody up the ladder will say, please don't report it as a fraud because tomorrow he'll be held accountable. That's why you saw this spurt in cases from 23,000, 27,000, suddenly 1,80,000 crores, 1,31,000 crores. So any case which failed became a fraud.
So, and that makes the Supreme Court ruling that much more important because, as you pointed out, Mr. Srivastava,
you need to give him a chance to explain. You need to point out why.
Yeah.
And then you need to document it. Now, obviously, the reason he would have, the borrower would have come, give him a fair chance to represent himself. There could be a genuine case of a failure.
Yeah.
So the fraud and the failure became indistinguishable. And you tended to err on the conservative by treating everybody as a fraud. Because tomorrow, the same investigating agencies will hold you up if there was actually a fraud there. So to be on the safe side, you actually made this. Now, the Supreme Court has done well by aligning it to the dispensation for willful default, by allowing, okay, you give the reasons for the fraud, let him reply to it, examine it, let him establish it, his innocence, and then take a call.
Yeah.
Now, obviously, this will be subject to questioning. He'll also go to the court. The borrower thinks he's right. But then the court has certain things to rely on. That there's been an application of mind, that there's been an application of discretion. So that is what is established. So I feel this is a very timely thing.
Okay, Nilang, I'll come to you for your first quick thoughts because on the face of it, it seems fair, right? That if you're getting debarred from the credit mechanism in the market, then it's fair that you're given an opportunity of being heard. But I'm sure there are sort of adverse consequences, so to speak, for the process itself.
I think quite apart from whether, where the decision of the Supreme Court went and whether it's fair to align with the willful default process, I think a point Mr. Srivastava made. It's not like the process of classification today is a bit of the wild, wild west, right? There are detailed guidelines set out both by RBI and also by banks' internal guidelines on how the process of identifying fraud is to be run. There is obviously, triggers, then there are investigations, there are various committees internally which discuss it. And in practice, and you'll see this even in the judgment, I think there are 4 or 5 cases whose facts are referred to. You can see that opportunity has been given. In some cases, unfortunately, in 1 or 2, not.
Yeah.
So in practice, in most cases, banks are not going to just, do a shady report on the side and classify as fraud. It is a formal process. The borrowers often reached out to. Their responses are considered. I think they're factored in. So I think even in practice today, in most cases, other than a few bad apples, the opportunity of hearing is there. Now, this has refined it a little bit. It's saying, it must be given at the time of the report. It must be given before you declare it fraud. There must be a reasoned order. I mean, I don't see any in principle objections with this. But I think what we really need to dig a little deeper into, Paswani, is take a step back and, what are we doing over here? As Mr. Srivastava said, the system is such today that default means report. Report. Inevitably, because of a combination of, the fact that the promoter is not cooperating, because of the fact that the thresholds referred to in these various master directions are quite low and broad, right? Because it's an indicative threshold. And therefore, they get triggered very easily in these reports. And 3, quite frankly, because, all these are done on an L1 basis, and there just aren't enough fees paid, and a lot of these guys don't have the justification basis the fees to go deep into a report, and therefore the reports tend to be high level, a little vague. Now, with that, what you have is a recipe for disaster. Because as Mr. Srivastava said, the guy looks at this and goes, I can't say it's not fraud, and therefore I got to say it's fraud. And therefore he passes it up the system. And in this, in this world where everyone's scared about CVC, CBI, no one's going to take a call that actually this is not the promoter who has defaulted because of an intra-group diversion. The reasons are justifiably commercial. Pipeline didn't work, tariff got revised, license got revoked. Incidentally, he seems to have moved money to the other group entity. That is not the cause for the default. Is that fraud? I'm not sure. I think it's certainly breach of contract. I don't know if that's fraud, right? But who's going to take that qualitative call? And how do we change this system of getting the fraud reporting a lot more qualitative than quantitative? I think that's the question.
So would you, Mr. Srivastava, say that the process now, because you have to give reasoning, you have to take into account the borrower's submissions and rebut that in your final report as a lender, do you believe that the anomalies or gaps that Nilang pointed out will get addressed in reports from now on, because they will, it's maybe a higher legal threshold for the reports to now sort of live up to?
So essentially, what Nilang is mentioning is all right. In theory, that is the system that should work. In practice, if a junior officer has written that there is a possibility of fraud, no senior officer is going to overrule that. Now, between relying on the report of a forensic auditor and the submission of a borrower, no banker in these days, especially, will rely on what the statement of the borrower is concerned, because they'll say, okay, further investigation. Further investigation will again come back to the same thing. By and large, it looks clear, but except for this. But everybody is trying to cover up for himself. Now that is.
But I'm saying qualitatively, do you think they do a better job now?
So anomaly is that now the anomaly is being corrected, because now you'll have to give the reasons why you're doing it.
Yeah.
It's not
so
like,
far, would you not give the reasons that, look, these are the 5 or 6 or 10 reasons because we are tagging this account as fraud? Do they not find a mention in reports today?
You go by what the forensic auditor has told you.
Okay.
Who's going to go against the forensic auditor? Practically speaking. It requires a lot of guts to say that forensic auditor, please give me the evidence. Now the forensic auditor, in some cases, he'll not be able to give the evidence, because he'll say, look, it's, I know some company which has land invested in Africa or in Dubai. Okay, you ask him for the evidence for that. They say, we don't have it, but we are telling you this is what has happened. Now, when you go and file a case in the CBI against the bank officer who's defending there, and there I have been personally part of defending such cases filed by the CBI, where the CBI judge has taken me to task, have you applied your mind? Where is the evidence? Now, if there is a provision that, okay, it has to be evidentiary, then, you move to the outright fraud cases, not the suspect and the gray. The anomaly happens in the suspect and the gray, not in the outright. But then the forensic auditors also need to be professional. As Nilang mentioned, if you go by L1, obviously you will get those caveated reports.
So Nilang, what do you think will change from now on? And also, does it now give a window to borrowers to, let's say, tie this process up into litigation? Is it sort of, do you think, because unless that gets over, your account can't get tagged as fraud? Do you see the possibility of that happening?
Yeah, so 3-4 things, right? One, certainly, if you saw, I think there's one example in the judgment which talked about a case where they initiated a report, declared it fraud behind the promoter's back. The promoter had no idea anything was happening. Those kind of bad apples, I think, and maybe there was a justification for that even there, right? Practical justification. Maybe that will stop, not maybe, that will stop. So certainly, I think there will be a more formal process of getting the responses, the evidence, and factoring them into the documentation. Will that cause delay? Potentially. Is there a promoter out there who will think, oh, you want answers? There are 21 truckloads of documents. Go through them. Have fun. Sure. But the fact that so far today, banks have already been engaging with the promoters in this context and been getting responses which are factored in. People are used to it. People are used to the delaying tactics. Come for a meeting. Oh, sir, I'm traveling. Oh, sir, I have a kidney replacement. Oh, sir, I will come 3 minutes later. All of that has been factored in today. It's part of the practice. It's not like suddenly banks will have to discover how to engage with promoters in this context. So I think there may be a slight, a period where the processes are made more formal, because, I think now if you have to give a hearing and a promoter delays 3 times, 4 times, 5 times, at what time do you say you've given him the opportunity? So that system will have to be set up. That system may be challenged. As long as the courts look at some of the systems and say, listen, it's a fair system. You were given an opportunity, you messed around, you sent 21 truckloads of nonsensical information, now it's done. Then I think after this interim period where there may be some challenging of this policy set down by banks, I think things will settle down again. So it should be back on track. I suppose the question is, again, going back like a stuck record to my previous point, how do you fix for qualitative fraud identification? And I think, as Mr. Srivastava said, no senior bank officer wants to take a contrary call to the chain of, downstream chain, which is taken a view. And the only way I think maybe that can be fixed is a third-party system. Whether the banks request the RBI, get together via IBA, form a committee, which committee can act like a mediator where they present a report, borrower comes in, and the committee takes a view. And the committee takes a view that actually this is, a promoter who breached covenants, but is not a fraudster.
Okay.
Then, the senior bank officers can go into the retirement without the worry of that sword coming after them 5 years later.
Anecdotally, Mr. Srivastava, I don't know if we have the data on this ready. How many of such fraud tagged account sort of reports pass muster in courts? Because I'm sure even today promoters challenge or borrowers challenge those positions.
No, there has to carry forward from Nilang's point. You see, the threshold of 50 crore is a large number of accounts.
Yeah.
When you're looking at accounts over 100 crore, over 500 crore, over 1,000 crores, there the scrutiny is much more intense. And obviously, you expect those borrowers to go to the courts, and therefore, you have to actually be more thorough. The forensic auditor is also more thorough. But when you come to the 50 crore accounts, you see the borrower himself, he is a, 50 crore means a turnover of 150, 200 crores, 250 crores. He doesn't have that wherewithal to actually manage all this. Okay. So in the willful default, you have a process. In cases of, cases being referred to CBI, for general managers and above, you had created a system of advisory board for, banking frauds under the CVC. And you also had an internal evaluation committee of outside members. But they will evaluate basis what you have submitted to them. And if you have submitted to them that, okay, based on the forensic auditor report, it's the considered view of everybody up the line of chain of command that this is a fraud, the internal evaluation committee will ask for certain data and evidences. So this was formed only a couple of years back. So that peak period of 1,81,000 and 1,31,000 happened in the 2 years right after the circular was issued. After that, there was a declining trend. So if you notice, it went down to 71, then whatever, then this year is probably 19,000-20,000 crores till now. So, it's coming now. But every case of failure cannot be a fraud. I know of an instance where a copper smelter, where he borrowed money against copper ingots and he didn't fix the price and it went adverse and he lost almost 40-50%. Now, by virtue of that, his smelter could not operate and he became an NPA. Now, for him to justify, look, it's a business failure, and he was only a 50 crore account. It is beyond the understanding of the small, the chief manager or the manager to understand the implications. He's looking at, look, forensic auditor, there has been a shortage in stock, and therefore there's a misappropriation. Okay, so those 7 cases which were, I'm saying Nilang can actually is a legal guy, he'll tell you, you yourself are a legal guy, because there are 7 types of frauds, which are very broad categories.
Yeah.
So if you look at that, in some way or the other, it'll fit into one category or the other.
Yeah.
So it's a judgment call. And a judgment call means that you'll have to, be convinced of what logic you finally adopt and what reasoning you finally give.
And
Okay.
so even
I
if
have
you
a
are
quick
convinced to have the
Nilang,
courage,
just one
go
second.
then
I have
put
a
that
quick
on.
follow-up to what Mr. Srivastava was saying. Just wanted to, because the Supreme Court has said now you have to share audit reports, and I'm guessing it also means the forensic audit report. Do borrowers get these reports now before they get classified as fraudulent? Their account is fraudulent?
I think different banks, and Mr. Srivastava will also have a view, different banks' processes differ, but certainly what most banks will do is they will highlight the incident, the act, the transfer, the asset, the liability, and say, listen, this is under suspicion. Can you explain this? So certainly
please,
that
Nilang, go
opportunity
ahead.
is given. And then, of course, the promoter knows that this is obviously being investigated, so let me give all the information and justify it.
Okay. Go ahead, Nilang. You were saying something earlier.
No, I was just saying, just to complete Mr. Srivastava's point, he was saying that you need, the judgment call, and you need to be convinced that it is not fraud.
Yeah.
But frankly, even if you're convinced, which bank manager wants to take the call on his head and turn out to be wrong, and even if right, for someone else to feel it is wrong, and then be attacked 5 years later, right? It's just not safe.
That is a fact. Absolutely, because even in the IEC, if you are going to represent before the IEC, you'll have to be convinced, and the IEC will note down that because Mr. Nilang has mentioned these, therefore they feel that okay, it's not a case of fraud. Ultimately, it goes to the same officer. So.
Yeah, no, and sorry, Payaswani, also, why is for some extent IBC being so popular? Because if a bank accepts 4% in a Videocon OTS, they are spending many years in an unhealthy and unhappy place. Yeah. But if they do it under an IBC's process, with a COC, with an RP, Deloitte has, run it. All the lenders agreed. The court stamped it. I'm protected.
Yeah.
So this is always top of mind.
Yeah, at least they don't have the Damocles sword over them of somebody asking them 5 years later why you took a contrary call when there was a possibility that this could be a fraudulent account. All right, thank you, Mr. Srivastava and Nilang, for giving us your thoughts on what the Supreme Court ruling could mean for lenders and borrowers equation. What I'm hearing from the both of you is some of the principles of natural justice are already followed by some banks, but now, of course, then embedded in the master circular itself as a consequence of this ruling. It may mean more time that gets spent before an account is categorized as fraudulent by banks, because now borrowers will get the forensic audit reports, an opportunity of being heard, and submissions basis which hopefully banks will give more reasoned reports. Mr. Srivastava and Nilang, thank you very much for joining us here on the Fineprint, and thank you so much for watching.
Thank you.